Officer Dave, would you open the courtroom for us, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Let's see what Ms. Francis has for us today. Ms. Francis, good morning.
Good morning, Your Honor.
So you got two cases with me?
I do.
You got 995?
Yes.
All right, I have Ms. Brown, so we'll get started on that one. Then we'll do your next one.
Thank you.
All right. Good morning.
Good morning.
We are on the record calling file number 14107-995 Velocity Investment versus Yolanda Danielle Heather Brown. This is the date and time. Oh, I'm sorry, it's Heather Brown and it's Heather Brown, sorry. This is the date and time for objection to garnishment. Your appearances.
Good morning, Your Honor. Navjot Francis, P72322 on behalf of Plaintiff's Attorney of Record.
And what is your name, ma'am? Ma'am, what is your name? In Michigan hat?
Oh, I'm Heather Brown. I apologize.
Ma'am, you are the moving party. What is the basis of your objection to garnishment?
I don't know who Velocity Investments is. After further research, it appears that this is a debt, I guess, that they bought from another company that I long settled with quite some time ago. So I'm not really sure how they came into possession of to be able to do a garnishment, because the vehicle was a voluntary repossession from 2010. And again, I settled with them. The other company was taking my tax returns as well as me paying them. And it's not on my credit report. It's not anything. So it's like this just came from out of nowhere.
Ms. Francis, you're muted.
Sorry, Your Honor, we do have a valid judgment. Defendant is trying to attack the underlying judgment, which is not allowed through the court rules through an objection to garnishment. So her objection should be denied.
Ms. Brown, the register of action here indicates you were personally served with summons and complaint on May 7th, 2014. And then a default judgment was entered against you on July 11th of 2014. There is a valid judgment against you at this time, ma'am. Now, you may not use the objection to garnishment, which is the only matter before the court today, to challenge the validity of the underlying judgment. The court rule is quite specific. Michigan Court Rule 3.101K specifically provides you cannot do what you're attempting to do. You cannot use the objection to garnishment to say there's something wrong with the underlying judgment. Having failed to state, what is it, ma'am?
I do apologize. Sir, I was never served. I put that also in my paperwork. I was never served.
I'm sorry, ma'am. I'm not being clear. Michigan Court Rule says you may not, 3.101K says you may not use the objection to garnishment to attack the validity of the underlying judgment. And that's what you're attempting to do. You're saying the underlying judgment wasn't valid because you had paid it off. You're saying the underlying judgment wasn't valid because you were served. The court rule says you cannot use the objection to garnishment, ma'am, as a method of attacking the underlying judgment. Having failed to state a valid objection to garnishment, your objection to garnishment, ma'am, must be denied. You have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. Court will send out to both of you today an order denying the objection to garnishment. Thank you both for coming in. We are off the record.
Thank you, Your Honor.
All right, Ms. Francis, what was your other case?
807.
Let's see again. 3807, that it?
I only wrote down the last three. 3807.
3807, okay, that's Francis. I don't have the opponent for that one as of yet. Put you back in the waiting room.
Thank you.
Yeah. Ms. Hal Burke. It's gonna be 496. Nathan Jones and Hal Burke. Nathan Jones. Hal Burke. Good morning.
Good morning.
Hello, Your Honor.
Good morning. We are on the record. This is file number 22-190-496. Beaumont Health versus Nathan Jones. Date and time for objection to garnishment. Your appearances.
Thank you, Your Honor. Hal Burke, P69068, attorney for Beaumont Health on this case.
And what is your name, sir?
Ethan Jerome Jones.
Mr. Jones, you are the moving party. What is the basis of your objection to garnishment?
Your Honor, the job gave me the paperwork. I didn't receive any, I have not received paperwork. And I've been at the same house 60 years, and I'm taking care of two geriatric parents, a 90-year-old father and an 85-year-old mother. And I never received the paperwork, but I got the garnishment from the job. And I only had one talking with a lawyer. And I told her or them back then a while ago, I would be able to set up a payment plan of $100 a month. However, they never got back with me. Only had one conversation, but never see no papers or was served. And that's all I'm saying, Your Honor. When the job gave me the paperwork, that's when I got it.
All right, Mr. Burke, your response.
Your Honor, I respect Mr. Jones. He did contact us in August. We reminded him, of course, that we did not represent him. You did grant us a default judgment. I haven't seen nor heard anything as far as a real defense to the claim. However, in the spirit of a resolution, I'd like you to, if you would, continue the garnishment on this case. However, I could have somebody call Mr. Jones today, or I could, and try to get him on a voluntary payment plan, if that would work better for everybody, as long as he remained on that plan.
Well, I have to make a ruling on this matter today. So
Yes,
this is
sir.
what I'm going to do. Mr. Jones, is there
Yes,
anything
sir.
else you want to tell the court about your objection to garnishment?
Yes, my objection was, Your Honor, I never received any paperwork until I got this paperwork from the job and the first garnishment, I think last pay period.
All right.
And I never received it. That's when I got it. The only thing I heard from, I think, a lady lawyer from Toledo was then, and I told her then that I wasn't able, and I said I would check with the insurance company, which was Priority Health at the time. Now the company has switched back to Blue Cross Blue Shield, because there wouldn't have been no problem with the payment. Your Honor, I have a basic insurance card outside of my insurance that I put $2,000 a year into that still got $1,000 on it that I could have used. However, I never knew. When I go to the doctor, I pay my co-pays, I get my medicine with this card. I had no idea of the situation. And on this basic card, you have to spend it or you can't use it. So I would have gladly paid, and I told this young lady I would gladly be able to pay $100 a month on that payment plan when she told me in August before I even knew about any of this, and I could have made those payments and still able to make $100 a month payment until that's paid. I understand because we come from a religious background. The Bible say, "Oh no, man." I know I owe the debt. I'm not trying to get away from the debt. I just was taking care of my parents. I don't have those funds behind a COVID come back off of myself. So I'm willing to pay them, but you're just taking chunks of change that I use to make things happen. So I don't understand it.
All right, I'm prepared to rule. Thank you both. The register of action in this matter indicates that you were personally served with summons and complaint at the same address that you use on today's pleading. That service occurred on or about July 24th, 2022. On October 31st of 2022, a judgment by default was entered against you. In regard to your not learning about the garnishment before it was served, the way garnishments work, sir, is that once the plaintiff has a judgment against you, he or that organization then files a writ of garnishment. That writ of garnishment is not served on you. It is served on the person, the employer, the bank, the credit union, the state treasury that the plaintiff thinks has money that belongs to you. That entity is now called the garnishee defendant. It is the obligation of that garnishee defendant, be it the employer, be it a bank, be it the credit union, to say your funds are being garnished. They notify you, and then they respond also to the garnishment and say, yes, I have money that belongs to Mr. Jones, or no, I do not. You have failed to state a valid objection to garnishment. Your objection to garnishment must be denied. You have an absolute right to appeal my decision. That appeal must be perfected within 21 days today in the Wayne County Circuit Court. What I'm going to do while I have you guys both here, I'll put you in the chat room so you can have whatever conversations you and Mr. Burke might find fruitful. We'll send out the order denying the objection to garnishment today. Thank you both for coming in. We're off the record. And let me get you to the breakout room. You can have your conversation.
Thank you, Your Honor.
Hello.
Should be soon. It should come up on the screen where it says join. You want to join that conversation. There you go.
Yes, sir.
Burke. That'll be a chat room for you and the lawyer for the other side, sir. You join. There you go. There you go.
5 songs of Lawrence Pope. The music of Henry Thaddeus Burley goes time in poetry. English poet Lawrence Nicholson, Henry Lawrence Pope. That was Willie Liverman. It was the baritone that used Paul Sanchez. The composer Henry Burley was also a well-known singer of this era, contributed to the 19th and 20th centuries. And in the 1890s, he became soloist for St. George's Episcopal Church in New York City. One biography saying some parishioners opposed hiring him for all white church because of his race. At a time when other white churches, the New York Episcopal community were forbidding black people to worship. It's also said in another history that James Morgan, a member of St. George's Episcopal Pastor, decided both to hire Henry Thaddeus Burley. 5 songs. This composer celebrating Black History Month at WRCJ. George Philip Telemann's music, some of his collection next to music, not love music, it's the music of the people of Columbia, WRCJ.
Judge, could you pass me for a moment? I'm on the record. I'm sorry.
Okay.
Thank you. I'm sorry, Judge. The other judge is still talking.
Okay.
Thank you. Thank you, Judge.
We are on the record. This is case 221-173-807. The file is entitled Galaxy International versus David Thornton. This matter scheduled for hearing today at 10 o'clock on defendant's objection to garnishment is now 10:41. Your appearance.
Navjot Francis, P72322, on behalf of plaintiff's attorney of record.
Ms. Francis, the defendant has failed to appear. His stated basis is the bill is based on a fraud account that valid papers have not been shown through regular materials. That's an attack on the underlying judgment, impermissible as a matter of law under MCR 2.301K. Defendant having failed to appear, no good cause of that failure having been shown, his stated reason being invalid, the objection to garnishment will be denied. We'll send out an order today. Thank you for coming in.
Thank you, Your Honor.
Have a good day.
You too.
That's going to